there, you're watching Governance Conversations, and I'm your host, Payaswini Upadhyay. A company's approach to governance is visible well before its market debut. And in India's tech startup ecosystem, some of the most celebrated names are now raising uncomfortable questions. At Groww, Swiggy, and Oyo, pre-IPO bonus and conversion structures appear to have been designed in favor of founders and early investors, leaving minority shareholders with diminished economic outcomes. I'm joined by Hetal Dalal to unpack how these structures work, why the law allows them, and what reforms are needed to protect retail investors. Hetal, if I understand correctly, at the heart of this conversation is Section 63 of the Companies Act that allows companies to issue bonus shares. But it is silent on whether those bonus shares must be strictly proportional for unlisted companies. So, in effect, if I can use an example, a company could design a so called bonus issue where the founders end up with two shares for every one that they hold, but other non promoter shareholders will receive only one. Could you expand on the specifics on how it played out at Grow, Oyo, and Swiggy?
Sure. Um, you're absolutely right. Under Section 63, while there is essentially ambiguity the in terms of whether the company has to have a proportionate bonus issue, and we looked at 10 startups which were recently listed, and of that we found that in three companies, Oyo, Grow, and Swiggy, there were bonus issues which were given out just pre-IPO. Now, the in both Oyo and in Grow, there was an opt-in for the residual shareholders. They could also equally apply or opt in for these kind of payout structures, but there's a risk-reward trade-off. Now, in Oyo's case, it was linked to the IPO. They gave shareholders about 3 days or 72 hours in which to opt in, and there was a host of documentation which had to be created for the opt-in, essentially acting as a deterrent. So therefore, those in the know who had access to whether the company is going to file the IPO or not, and had the ability to produce the documentation quickly, were the only ones who were able to opt in. And the difference was fairly egregious, from 1:1 to 1,100:1. In Grow's case, also similar, where there is an opt-in which was given to all shareholders, but there's no available information on what the metrics were for the opt-in to actually work. So what were the underlying triggers where the opt-in would work is unclear from publicly available information. You would expect, though, that investors, while they would have got that access when the issue was being pronounced. But in Grow, interestingly, there was a higher upside and a lower downside. So if if the triggers were met, then the amount of shares you get would be significantly higher. But if the triggers are not met, then you would be getting significantly lower than the 1:1, which is otherwise available to the residual shareholders. Now, the question to ask in all these structures is that, do residual shareholders have sufficient information to make a judgment call on whether these triggers would be met or not? In Swiggy's case, while the bonus issue was the same, but the conversion ratio was different for key management personnel vis-a-vis the rest. So the entire issue rests on whether investors have enough information.
I want you to articulate the principal objection that we have, with these issuances, because SEBI's ICDR regulations mandate that the issuances need to be proportionate to your shareholding, so that all shareholders of the same class are treated equally. Can I not argue then that companies that are unlisted, they shouldn't be held to the same governance standard as their listed peers? Because that's the argument I would think most of these companies would take.
That's a fair argument, and that's held true for a very long time. But look at the underlying philosophy of why the standards for listed companies are more stringent. Essentially, the standards are stringent because you have a set of retail shareholders, you have a set of minority shareholders who are not in control, and therefore governance structures need to be stronger. And at the point in time these regulations were made, the only thinking really was that when it's an unlisted company, you don't have outside shareholders, and even if you do have outside shareholders, these are discerning outside shareholders, right? But that's not true anymore. You now have a vibrant unlisted market, and the fact that You now have individuals, retail shareholders who are getting into the unlisted space. To just look at NSE's number of shareholders, like significant. So therefore, it's now become incumbent upon the regulation also to look at unlisted companies in a much more meaningful manner. And maybe there is a case to be made that if you have, shareholders till a certain threshold, then maybe the rules and regulation and governance standards of listed companies apply.
Sure, point taken. And so by attaching, the different conversion ratios to different holders, a company can ensure that some shares would eventually turn into far more equity and potentially more voting power. And I would think here's where Section 48 of the Companies Act also has a role to play, because it says that if you are varying any shareholder rights, that needs to be approved by three-fourths of that shareholder group. Are these bonus issuances then a variation of shareholders' rights in disguise to your mind?
It is, effectively. You can argue that the opt ins were given, but the deterrents for the opt in are significantly high. And therefore, essentially, this operates as shares with differential rights and more favorable to a set of insiders and not the outsiders.
Yeah. So, if I understand, the conditionalities also are slightly sort of unfair that come with these issuances, like the ones you pointed out, right? That it's a very limited short window for any shareholder to assess which option to pick. Also, the fact that they don't really know when the IPO or the milestones will be achieved. Is it then sort of fair to say that you do these issuances, you give shareholders ample time, and you make a certain set of disclosures? Will that make the entire process more palatable?
Yes, I think when you have a set of outside shareholders, they need to be treated equally. When there is a sufficiently large pool, and you do need to provide them sufficient information. Let's not take away the fact that where investors invest in unlisted companies, the governance standards are not as stringent as listed companies, and therefore there is, to an extent, buyer beware kind of a risk. But that doesn't take away the fact that the company creates structures and creates deterrents, in terms of paperwork, documentation, timelines for the outside investors to exercise equal rights. And that's clearly an element of concern.
And let's say that transparency doesn't come in, and companies are not making those adequate disclosures. What is the fix then for what, if I can call them, pretend bonus issuances, both at the regulatory and at, let's say, a board level?
Well, in an unlisted, like I said, I think first at first point in time, the regulation need to step in and take a look at companies where they have that large unlisted and have a large minority shareholder holding. The number of shareholders is significantly huge, right? The other is, of course, more transparency and better timelines, and this is where the board comes in. The role of the board comes in also recognizing the fact that there are stakeholders outside of the institutional investors or the private equity which is invested, which are also now whose wealth is also now attached to the fortunes of the company. And while you may argue that promoters do need a little bit of the upside before the IPO, and that's a reasonable argument given the fact that a lot of them have taken on challenges, built disruptive businesses, thought of new ideas, and done something well effectively daring. They therefore do need to be rewarded for that risk that they've undertaken and for the business that they built. It doesn't take away the fact that your non-controlling shareholder or non-founders who are small and not necessarily on the board table also need to be protected.
Okay, so let's hope the companies on the road to IPO are listening and the regulators are listening and make these bonus issuances a lot more transparent and fair. Thank you, Hetal, for explaining the principle of the issue here, and thank you so much for tuning in.